Well, good afternoon, everyone. Thank you for attending. This is going to be our last Murphy event for the semester. So thank you all that are here in person. Of course, those are online as well. Thank you for attending. We're excited to have you all. My name is Tommy Medikalel. I am a 1L student here at St. Thomas. I am also a Murphy Scholar. The Murphy Institute, of course, is a collaboration between the Centers for Catholic Studies and the School of Law that works to engage the Catholic intellectual tradition and the practice of the legal profession together in a way that creates meaningful discussions and debates on the law and public policy through the lens of the Catholic contemporary perspective. So after Professor Sisk's presentation, there will be a time for some Q&A. Professor Sisk will handle the Q&A here in person, and we'll also have the ability to answer Q&A questions through the online format as well. So people on Zoom should be able to see a Q&A box towards the bottom of their screen. You're welcome to utilize that function to ask your questions as well. For those looking for CLE credit, just make sure that you do email your attorney number to our Murphy Institute email, which for those in person, it is sitting right over there. And then if you are here, of course, you can sign in at the table at the very front as well. And the CLE code will be posted on the Murphy Institute website as soon as it is available. So now it's my honor to introduce our speaker, Professor Gregory Sisk. Professor Sisk has many accolades and experiences to his name, but if you ask me what his most admirable traits, I would have to say kindness. I took civil procedure with Professor Sisk last semester, and if I had to pick a particular memory, it would have to be he took a group of students out to lunch at the Lunds, which is very close by here. And he sat down with us and took the time to get to know all of us one-on-one, get to learn our law school journey, why we were here in the first place. And I think that's an admirable quality that I love to see in any profession, any teaching profession. I think it's particularly admirable in such a space where academic rigor and competition is so key to the law school experience. But Professor Sisk truly values learning and getting to know the individual person, which I think is wonderful. I think something else that if you ever get a chance to ask Professor Sisk, he has a wide variety of props that he likes to bring to our civil procedure classes. I think my favorite has to be one of the original dolls from the Christian v. Mattel case. So he's brought that in every time we talk about the case, which is, I think, one of my favorite things. There's plenty of bobbleheads and other things too. So if you ever get the chance to see his office, he also has those in there as well. But without further ado, to speak about the free exercise clause, here's Professor Sisk.
Thank you very much. And thanks for being here. And for those of you who are online, when you were saying that you thought of me as kind, my daughter was married right down the street at the Basilica last year. And at the rehearsal dinner, that's when the groom's father gets to speak. And he said that he had asked my daughter, Katie, what was the one description she would have of me? And I was very interested to hear what that would be. And she said, soft-hearted. So it kind of fits in with what you're talking about there. Hopefully that's a good thing most of the time. My name is Gregory Sisk. I'm a co-director of the Murphy Institute, and delighted that we're able to start transitioning back to being in person. We're going to have all of our programs, or most of our programs now, have an in-person option. I suspect that as time goes by, there'll be occasions in which there will be an in-person only option as well. But we know that we have those who find it difficult to make it all the way to the law school, especially on a day where it's been pouring rain. So we will continue to have online options as well. Last year, I presented our empirical study of Establishment Clause cases in the federal courts during the period of 2006 to 2015. And we reported the persistence, the troubling persistence, although an encouraging decline, of a partisan influence on Establishment Clause cases in the federal courts. That is, judges appointed by Republican presidents were significantly more likely to reject Establishment Clause claims than were judges appointed by Democratic presidents. And at the time, during the question and answer session, some were saying, but you're neglecting the other half of the First Amendment. In addition to the Establishment Clause, there's the Free Exercise Clause. And my response then was, stay tuned. So this is that point two where we are bringing that into play. This is part two of our empirical study of these religious liberty cases for this particular period of time. Professor Michael Heiss at Cornell Law School and I have been doing empirical studies of religious liberty decisions that now have covered 3 decades in the federal courts. And the most recent period that we have looked at, as I said, is 2006 to 2015. Our article reporting on this study is forthcoming in the Arizona Law Review, and it is already available online. So if anyone would like to actually see the entire article, which describes a number of other factors that I just don't have time to get into today, all you need to do is Google Sisk and equilibrium. And the last time I checked, it's the very first one that pops up. And then there's an option to download a PDF. I don't think you have to join SSRN to do that, but if you do, it's safe to join it. It's a free service, and you will not be receiving emails if you don't wish to gain access to a copy of that. So drawing on, let me make sure the PowerPoint slides are doing what they're supposed to be doing. That's always encouraging. So drawing upon our empirical study of religious liberty decisions, we find that the federal courts are approaching what we call equilibrium in outcomes. In a departure from our prior studies, which examined the preceding 20 years, we now observe that claimants from the majority of religions did not experience either success or failure at significantly different rates. So we may be witnessing the possibility of equality of opportunity for Americans of widely differing religious views in obtaining accommodation on religious grounds against various governmental regulations and policies. Perhaps the age of religious liberty only for a few favored religious groups may be coming to a close, bringing us closer to a future in which religious liberty is equally enjoyed by Americans of all faiths. The Merriam-Webster dictionary defines equilibrium as a state in which opposing forces or actions are balanced so that one is not stronger or greater than the other. The followers of one religion should not enjoy a greater probability, a greater advantage, or a weaker disadvantage when seeking state recognition of religious practices, if that unequal result is based on religious identity or the cultural domination of a particular religious tradition. If religious liberty in America is to be genuinely available in practice as well as in theory, it must mean that every person of every faith may expect equal consideration when presenting a demand for accommodation of religious exercise against governmental restrictions. So let me begin with a few words of history of religious liberty in the United States. America's history of religious tolerance has been blemished by inequality and intolerance. During the 19th and early 20th century, Mormons were attacked by mobs. Immigrant Catholics were assaulted and subjected to regular discrimination in urban centers, and anti-Semitic attitudes limited educational and employment opportunities for Jews. During the surge in patriotic zeal after World War II, children of Jehovah's Witnesses were forced to salute the flag in public schools. As the war on drugs accelerated in the 1970s and 1980s, sacramental use of peyote by Native Americans was interrupted by strict enforcement of drug laws. In the first period that we studied in our empirical study of religious liberty, for 1986 to 1995, we found that traditionalist Christians, such as Orthodox Catholics and Baptists, were significantly less successful in seeking religious accommodations. Resistance by traditionalist Christians to the application of social welfare regulations and the application of anti-discrimination laws to church-related institutions was suppressed in favor of secular requirements. So for those of you who are in the room, I'm going to let you know, I've got a stool here that I'm going to be sitting on through much of this, both because you can probably see the PowerPoint slides a little bit easier. The other reason is that I became a cyborg last fall when I had the first of my knees replaced with metal. It's the result of the surgery has been very good so far, but standing is the one thing it doesn't like me to do for too long. So I'm going to lower myself down to do this. When we identified this effect of a disadvantage for those who came from traditionalist Christian viewpoints, we suggested that they were entering into the courts struggling against negative perceptions and attitudes by political and legal elites. While they were comfortably within the mainstream of Christian values, they stood opposed to the values of those in urban areas in particular who had the power to impose additional restrictions or adopt a different approach in policy. So the parallel resistance of Catholics and Baptists to various social welfare regulations, and especially the application of anti-discrimination laws to church-related institutions, ran hard against the liberal secular side of the so-called culture wars. This led judges to find that those present-day secular priorities were sufficiently compelling to override the claims of religious exercise. As I'll explain a little bit later on, this has changed, and there appears to be some significant reasons for why this has changed. But just as the disadvantage for traditionalist Christians seemed to be fading in our empirical study of the next period of religious liberty decisions for 1996 to 2005, we found that Muslims almost alone were significantly and powerfully disadvantaged before the federal courts. During this era of 9/11, Muslim claimants were predicted to succeed in free exercise accommodation claims at only about half the rate of non-Muslims. Well, I'll come back to talking about how this has changed in a moment as well. So as we now bring our continuing empirical study of religious liberty decisions before the federal courts into a third decade, 2006 to 2015, we have an unprecedentedly large and inclusive data set of 2,847 observations of federal judges. This includes judges from all 13 of the federal appellate circuits and from 90 of the 94 federal districts. Reaching into this new period, things may be inching toward that aspirational point in which claimants from most religious backgrounds across the spectrum of American religious experience appear to suffer no systematic disadvantage in seeking accommodations for religious exercise. With shrinking exceptions, judges of the federal courts of appeals and the federal district courts appear to be adjudicating constitutional and statutory religious claims with even-handed impartiality. As we have in our prior studies, we have defined religious free exercise and accommodation cases to include first, claims arising directly under the Free Exercise Clause of the First Amendment of the United States Constitution. Second, claims based on federal statutes designed to promote freedom of religious exercise and speech, such as the Religious Freedom Restoration Act and the Religious Land Use and Institutionalized Persons Act. Third, claims under the Free Speech Clause of the First Amendment involving alleged governmental suppression of expression that was religious in content. And four, charges against governmental entities of discrimination or inequitable treatment of religions of individuals or organizations based on the religious nature identification. This includes equal protection constitutional claims and employment discrimination claims against government employers. A substantial majority, 60.2% of the claims addressed by the judges in this data set were premised, at least in part, directly on the Free Exercise Clause. The next largest claim category came under religious freedom statutes. That was 45% of the observations, followed by assertions of unequal governmental treatment, which was 39.1%, and free speech claims for religious expression, 21.7%. As we examine the digested federal decisions from 2006 to 2015, we coded for the direction of each ruling, the general type or category of the case, the religious affiliation of the claimant and of the judge, the religious demographics of the community in which the case arose, the judge's ideology, the judge's race and gender, and various background and employment variables for the judge. The religious liberty claim was favorably received by the ruling judge 37.7% of the time. In the 30 years of decisions in our studies, this success rate has remained remarkably stable and falling within a 2 percentage point band. For 1986 to 1995, the positive ruling rate was 35.6%. And for 1996 to 2005, it was 35.5%. Now, again, what is most remarkable for the 2006 to 2015 period is what we now find, that is, major religious groups having neither a significant advantage or disadvantage. Claims by Catholics, mainline Protestants, Baptists, Seventh-day Adventists, Mormons, Muslims, and others did not achieve success or failure at a significantly different rate than for claims of the same type made by others. Maybe we are inching toward that ideal point of equilibrium in religious liberty, where decisions are made based on the merits within categories of cases, rather than on subjective attitudes about this or that religious affiliation. So let me return to the example of Muslim Americans. As noted, for 1996 to 2005, the Muslim claimant variable had a substantially powerful correlation with the dependent variable and in a negative direction. If we hold all other independent variables constant at their means, the predicted probability that a Muslim claimant would succeed in presenting a free exercise claim to an individual judge between 1996 and 2005 was only 22.2%, while non-Muslim claimants succeeded at a rate of 38%. By contrast, for this most recent period, 2006 to 2005, the Muslim variable is not significant. And the size effect for the Muslim variable, even if we ignore the absence of traditional statistical significance, has become substantially smaller. Holding all other independent variables constant at their means, the predicted probability that a Muslim claimant would succeed in presenting a free exercise claim is now 34.1%, while non-Muslim claimants succeeded at a rate of 38.9%. I emphasize again, that difference is not statistically significant. But again, even setting aside that statistical significance, the success ratio declined from 1.7 to 1.1. Now, while equilibrium may be in sight, we have not quite arrived. Our findings suggest that two minority religious groups, Orthodox Jews and Rastafarians, remain at a disadvantage. And two other minority religious groups, Buddhists and perhaps Native Americans, benefit from a comparatively greater rate of success. Yet even these exceptions further highlight the remarkable absence of evidence of the type of discrimination that historically has been suffered by such prominent religious groups as Catholics, Baptists, and Muslims. Now, as important as the variables that do not achieve statistical significance in our study are those which do. Our case type variables are strongly and robustly significant. And these are precisely those variables that should correlate with the outcome of religious liberty disputes. In an ideal religious liberty doctrinal regime, the balance between accommodating religious exercise and upholding important governmental purposes will shift with the character of the dispute as defined by those conflicting interests. Rather than the case turning on non-contextual and perhaps implicitly biased views of a particular religious claim, the contextual approach demands a deeper dive into the nature of the religious claim and a fine-tuned assessment of the government's claim of an overriding public interest. We would expect then that in some contexts are more likely to pose particularly troubling invasions of the government into private religious behavior, while others are more likely to implicate a compelling public interest in preventing harmful behavior. Douglas Laycock and Thomas Berg of St. Thomas Law School anticipate and welcome this evolution of the balancing approach for religious liberty claims, saying that, quote, over time, courts can use their experience with cases to define distinctive rules for categories of cases, much as they have developed categorical rules for different free speech cases like defamation or incitement of illegal conduct. So for each of the free exercise accommodation observations, we included a coding according to the case type, defined in terms of the factual elements of the case or the subject matter. And for 2006 to 2015, this coding was used to create the following 12 dummy variables. And I've included a red asterisk for those that are significant. Of our 12 case type variables, 8 of them are significant. a really truly robust indication of the importance of these categories. And those include public and secondary higher education, private education, religious meetings, religious expression, zoning, prisoner cases, exemption from anti-discrimination laws, and criminal defense. So let me discuss just a few of these. First, the case type variable for exemption from anti-discrimination laws is both very significant at the 99% probability level and very large in substantive effect. Holding all other independent variables constant at their means, the predicted probability that a religious claimant seeking an exemption from an anti-discrimination law would succeed was a whopping 87.2%. While claimants raising other free exercise accommodation claims succeeded at a rate of 36%. Now, as I mentioned earlier, our suggestion for the reason why traditionalist Christians in an earlier period did not succeed very well is that these types of claims were not successful when raised by those claimants during that time period. That has obviously changed quite dramatically. And the reason is that it follows very closely from the Supreme Court's 2012 decision in Hosanna Tabor Evangelical Lutheran Church and School versus the EOC, which emphatically confirmed that the First Amendment is the foundation of the so-called ministerial exception to anti-discrimination laws. In Hosanna Tabor, the court applied the ministerial exception to preclude an employment discrimination suit against a religious school by a teacher who held the title and responsibilities of a minister. As another example, because freedom of speech is one of the most highly venerated and vigorously protected of constitutional rights, being subject to infringement only for the most compelling of reasons, claims of religious expression ought to be among the strongest religious liberty claims on the merits. And two of our case type variables capture that, and both are, as we suggest they should be, significant and powerful. First, holding all other independent variables constant at their means, the predicted probability that a claimant would succeed in presenting a free exercise claim based on a request for a religious meeting in a public space was 69.2%, while claimants in other case types succeeded at a rate of 37.6%. Second, again, holding all independent variables, other independent variables constant at their means, the predicted probability that a claimant asserting a First Amendment right of religious expression would succeed was 56.4%, while claimants in other case types succeeded at a rate of 36.5%. Now, as one final example for now, we discuss others in the paper, and one that confirms that the context contingent nature of free exercise claims is a significant variable is that for criminal cases. Holding all other independent variables constant at their means, the predicted probability that a claimant would succeed in presenting a free exercise claim asserting rights in a criminal case was only 20.1%, while claimants in other case types succeeded at a rate of 38.2%. That claims for exemption from general criminal prohibitions on behavior are negatively associated with a dependent variable that is less likely to succeed is unsurprising. In the criminal context, especially when a violent crime is involved, as was often true in the cases in our data set, the government's interests are exceptionally likely to be perceived as compelling. Cases coded as criminal in our data set included such matters as use of a criminal defendant's religious writings or prayer journals as evidence of criminal conspiracy, religious motivations behind a conspiracy to commit a terrorist attack, and even claimed religious justifications for violent attacks on those who departed from religious expectations. In sum, in an ideal religious liberty doctrinal regime, the balance between accommodating religious exercise and upholding important governmental purposes will again shift with the character of the dispute as defined by those conflicting interests. And our encouraging results suggest that the driving force in deciding religious liberty decisions increasingly is that contextual background to the case. And so finally, what is it that brought us to the point where equilibrium appears to be in sight? If equilibrium is emerging and most religious groups are no longer enjoying or suffering disproportionate success in making free exercise decisions, developments in legal doctrine may point us to the reason why. A key possibility would be found in the Supreme Court's 2006 decision, right at the beginning of this period that we studied here, in Gonzalez versus O Centro Espirita, which provided the tools for loosening the grip of stereotypes. This decision held that the government could not preclude a religious sect from sacramental use of hallucinogenic substance by the, quote, mere invocation of a general prohibition on non-medical use of narcotics. By instead requiring an individualized, case-specific scrutiny that focuses on the religious claimant's particular attributes, the O Centro decision encourages the judge to abandon stereotypical generalizations and engage in a differentiated and individualized treatment of the case. In this way, the court may better appreciate the character of the claimant's religious practice and the nature of the required accommodation. To undertake that examination, the judge should learn about the claimant's faith perspective, objectively and rigorously, but also sympathetically, thereby substituting new information and understanding for implicit biases. Mark de Girolami of St. John's Law School similarly envisions this approach to adjudication of religious liberty cases in what he calls the method of tragedy and history. This, quote, takes much more careful stock of the values that both sides, the religious claimant and the government, bring to bear. In rough term, this method asks the judge, quote, to describe fully the nature of the conflicting values and the societal and doctrinal context that applies to the case. In sum, the Supreme Court appears to be setting the stage for a more expansive protection of religious liberty that also demands paying closer attention to the religious needs of each claimant, while not neglecting the interests of the government. As this inquiry is more conscientiously applied, it should produce more equitable results, as our study suggests is now being realized. Nearly 80 years ago, Justice Hugo Black, writing for a majority of the Supreme Court, proclaimed that the free exercise clause of the First Amendment means that government, quote, cannot exclude individual Catholics, Lutherans, Mohammedans, Baptists, Jews, Methodists, non-believers, Presbyterians, or the members of any faith, because of their faith or lack of it, from receiving the benefits of public welfare legislation. This is what we mean by free exercise equilibrium, that the blessings of religious liberty would be experienced evenly by those from all walks of faith. Our latest empirical study of religious liberty decisions in the federal courts offers some hope that we are approaching that equilibrium. Again, for this period, the substantial majority of those seeking accommodation for religious beliefs from a wide variety of religions, including Catholics, Muslims, Reformed Jews, Seventh-day Adventists, and a number of minority religions, did not experience a significant advantage or disadvantage in the federal courts. Supreme Court decisions strengthening the free exercise doctrine and focusing the judicial inquiry on individual attributes rather than on stereotypes may be bringing greater equality into the process. And the powerful significance of the case type variable suggests that case categories are properly driving the outcome. Professor Andrew Koppelman optimistically proclaims that religious liberty in America is a spectacular achievement, in which, quote, a growing proliferation of remarkably different religious factions live together in peace and even some harmony. Through the rise of cultural tolerance, a deepening understanding of the sincere beliefs of others, and conscientious judicial attention to religious claims that counter implicit biases, the courts may be moving us closer to that ideal of robust and widely enjoyed religious liberty. Thank you. And I'd be happy to take your questions. We'll finish very, very early. Yes.
So the last decision that you listed you talked about the judge being called to have an understanding and individualized perception of the individual's faith. Doesn't that get like dangerously close to the judge acting as like a religious arbitrator? That's something that they don't really want to do, like say this is true to your faith and this is not true to your faith.
That's another aspect of this, this part of the doctrine. We're not talking here about the first step of a free exercise claim, that is determining whether it's a sincere religious belief. And the Supreme Court has been increasingly clear in stating that it is not a proper role for judges to evaluate sincerity based upon their own understanding of what a religion is. So for a judge, for example, to say, well, my understanding of being Catholic means this is central to being Catholic, and that is not, and since you're raising something that I don't believe is central to being Catholic. Instead, we're talking about taking the religious believer where they're coming from. So what we're talking in terms of understanding that claim, we're talking about understanding that claim from the perspective of that religious believer and coming to a better appreciation of what it is that they're saying and how the government's interference with that is impacting on their lives. And so we don't just respond to a claim by a Native American or a Latino religious faith that uses a hallucinogenic substance, or a Catholic who uses an alcoholic substance in the process of the sacrament, and saying, well, we have other reasons why those are very bad things. We don't allow children to drink alcohol, but are we really going to bar children, those under the age of 18, from receiving the wine at the Mass? Are we going to apply general laws that prohibit use of narcotics for mind-altering purposes independent of religion to apply to individual religions that use that? So it's important that this not go to the point where judges begin to become arbiters, as you rightly put it, of what is and is not central to a particular religion. But it is important for judges to understand where that person is coming from and to develop an understanding of who they are that's not simply informed by stereotype. If you study implicit biases, and we all have them, it's not something that any of us can avoid. The way in which you overcome an implicit bias is to learn more about the group or category that you're talking about, and be able to substitute that more particular information for the stereotypes that otherwise are perhaps affecting what you're doing. Yes, please.
It sounds like you're implying empathy is an appropriate judicial attribute before they exercise judgment.
Yes, I am, but empathy understood in a particular way. And so I'm sure that what you're referring to is the debate that has occurred in terms of confirmation hearings for judges as to whether they're relying upon empathy rather than following the law.
Jeff Sessions thought it was a disqualifying factor.
Exactly, and those questions are raised there. So it depends on, of course, what we mean by empathy. If what one is saying is my empathy for this plaintiff causes me to override the law and not follow the law, that's problematic. Because then what we mean by empathy is your own personal and subjective preferences as to what should be the correct outcome. By contrast, genuine empathy that's appropriately used by a judge is to come to a full understanding of both sides of the case, to really be willing to listen and understand completely where the plaintiff is coming from, and to understand completely where the defendant is coming from. That makes cases, deciding cases where there is balancing, as there is in a free exercise kind of, it makes them a lot harder, to be sure, because you can't just apply a categorical conclusion and say, well, non-medical use of narcotics, we're not going to allow that. An accusation of employment discrimination based on pregnancy, that's going to apply to a religious institution just as it does to everyone else. Categorical approaches like that are a distinct lack of empathy, at least empathy in the way in which I'm talking about it. So a judge really does have to do the additional hard work of being empathetic. And again, not just to one side, and not just in terms of what is the preferred policy outcome, in which case then I'm in full agreement with Jeff Sessions that empathy is a substitute for the law. Empathy, by which a judge changes what the statute actually says that the Constitution is designed actually means in order to approach a political value. That's problematic. But empathy that is even-handedly applied, both to fully understand where is this religious claimant coming from, how is this affecting the way in which they're experiencing their lives, but also empathy for the government and fully understanding what is the interest that they find to be compelling. I think what we find is, as we look at these cases, and this, I'm not saying this empirically, but more anecdotally, I particularly see this in the prisoner cases, is that when you really push back at the government to justify a compelling reason, often it proves to be rather thin. That the government in the past has not had to go very far in establishing that there really was a compelling reason other than, well, we apply this same rule equally to everybody. And the government would win. Now that the government is actually being required to come up with a rationale, we find that they're often shifting and spinning and coming up with ad hoc reasons that had nothing to do with why they really did it. And sometimes once we poke all the way through it, we find out it's just because that's what they felt like doing and they don't want anyone to question that. Let me follow up on that just a moment. I'll take some more questions by talking about prisoner cases, something that I didn't address in the presentation here. When we first started working on religious liberty cases, I was a little concerned about having prisoner cases, or concerned that we would have to treat them differently. My assumption was that prisoners were going to lose at a much greater rate because as I know from other work that I do involving prisoners, prisoners are America's present outcast society and are not very positively thought about by most in society. So I assumed that they would lose at a very great rate and we'd have to exclude them as atypical cases. Turns out that they win at a higher rate than others. The prisoner cases actually succeed. And when you drill down to find out why, you find out that the prison's reasons for suppressing religious practices or religious requests are often just, well, that's just the way we do things here. And there isn't really a very good reason behind it. So empathy for the prisoner and understanding the religious principle includes empathy for the government as long as the government really has something behind it. And it turns out too often, as even conservative members of the Senate, when voting for the Religious Freedom Restoration Act, acknowledge there's a lot of arbitrary and randomness that occurs within prisons. Yes, please.
Yeah, I was going to ask about the data since 2016. Have you started looking at that, or what's your plan to look at that?
My plan is to be faster in turning it around than I was this last time. This last time between the pandemic, which disrupted things around here quite a bit, and in my own surgery, I fell a bit behind on things. So we're going to do 2016 to 2025, and to try and be able to turn that around, I already am planning in 2024 to start to work on collecting the data and then following up again in 2025 and then finishing up in 2026. So it'll be interesting to see whether these same trends continue. They should, for this reason. The Supreme Court's most recent religious liberty decisions are, if anything, doubling down on the results of cases like the Ocentra case and Hosanna Tabor. That the Supreme Court is expanding the ministerial exception in some ways. The Supreme Court is much more likely to demand that the government come up with truly compelling reasons for everything from preventing religious institutions from having public worship during the pandemic, to most recently questions about whether a person being executed has the right to have a religious counselor with them at the execution, where the Supreme Court voted 8-1 that was something that should be required, and that Texas's rationales for why they would exclude that person from being not only present, but putting hands on that person were really pretty thin justification. So I think that will continue. I can't promise that, of course, which is why we'll have to drill down and look at that. There was another factor that I haven't discussed here. We mentioned it some in our paper. Over the course of the 30 years that we've looked at this, we have not found that a partisan-based influence on free exercise decisions. Very much so on the Establishment Clause side. There it's been very powerful. It's becoming somewhat less so. I think the Supreme Court's calibration of the doctrine is making that partisan divide shrink some, but it's still there. But we haven't found it on the free exercise side. There is a recent study looking just in the most recent couple of years that suggests that now that there is one, that there is a significant Republican appointed judges are far more likely to approve religious claims than Democratic appointed judges. It's certainly possible that has suddenly emerged. it would be a rather dramatic change from what, I mean, when we look at the data for this period, again, not only is it not statistically significant, but it's not substantially large in size effect either. So that would be a pretty dramatic change. The study that did that was not a multivariate study that took into account other variables that might be driving those outcomes. So it could be that the partisan divide is a proxy for something else. But given how big that study found the divide to be, it certainly would taking another. Yes.
I have a few online questions.
Please.
So first one here is, have you looked at whether certain plaintiffs of particular religious persuasion tend to bring certain types of claims more consistently than others? Is there a concentration of Buddhists seeking accommodations in education, for example?
Minority religions, both Muslims and actually Buddhists as well. And the number of Buddhist cases is very small overall. Are concentrated in the prisoner category, for example. Now, if I were to speculate as to why Buddhists do better on average in raising those cases, again, prisoner cases, we have the empirical evidence that they do better. That I can say concretely. The reason why, once you get into the realm of the reason why, there is a degree of speculation. I hope it's informed speculation that Buddhist practices are particularly peaceful and non-threatening, and so prison security claims directed against a Buddhist who is asking for some prayer accommodation are especially likely to be weak. But Muslims don't fare better or worse any longer. But even in the period in which there was this really distinct difference where Muslims were losing at a rate about half of that of others, it wasn't the prisoner cases that was driving that. We differentiated between prisoner cases and non-prisoner cases, and the same phenomenon existed in both categories. Now, in terms of more traditionalist Christian organizations, you're going to see a lot more of them in the anti-discrimination category. It tends to be traditionalist Christians that are raising the ministerial exception cases because they find themselves on the receiving end. Catholics, Lutherans, other mainstream and evangelical groups find that discrimination claims are being brought by those who are in teaching or ministerial positions, and the organization is resistant, saying we do not want the government to be evaluating. When we say that we fired this person because of a doctrinal reason, and they're saying, no, the real reason was that I was a pregnant woman. Well, you can't adjudicate that without evaluating whether we are correct in our doctrinal analysis. And the Supreme Court's response to that has been, that's right, that there is a First Amendment-based ministerial exception, and you cannot, the courts cannot become involved in that. It's not only traditionalist Christian and traditionalist Jewish organizations that find themselves in that position, but disproportionately, you're going to find more of them there.
Sure. So a little bit longer. So a possible area of inquiry is how much money is dedicated to bring suits on behalf of Christians as opposed to Muslims, Buddhists, etc. And then there's a little bit of an explanation. So the equally urine thesis only has merit if we assume that plaintiffs choose which suits to bring at random. Many factors influence which suits to bring, including money. If you only have resources to bring one suit, you bring the suit you think will have the best chance to win. If you have additional resources, you bring the suit with the second best chance, diminishing marginal returns. Thus, the more cases that are brought by any given party, the more we should expect that party to lose. And the bottom line here is if Christians bring disproportionately more suits than Muslims yet succeed at the same rate, that would still demonstrate an evidence of bias against Muslims. So the original question is how much money is dedicated to bringing suits on particular religious groups?
To measure that directly would be next to impossible. I just don't know where you'd find the data to evaluate how much litigation funds are dedicated to particular lawsuits. So we're limited by that data being available. We have in the past attempted to find a proxy for something like that by coding for those who are bringing claims in an individual capacity. And those are bringing claims in an institutional capacity, that is a church or a mosque, a religious school as opposed to an individual, and see if that made a significant difference. We did not find that to be the case. Another category which suggests that that's not at play, or at least not at play everywhere, are the prisoner cases. The overwhelming majority of prisoner cases are pro se. Prisoners find it very hard to find counsel for a variety of reasons. Mostly, which is it's unlikely that the lawyer will ever succeed in a way that results in the attorney's fees being paid. For reasons far beyond what I can go into here, the procedural restrictions and the limitations on attorney's fees to lawyers for prisoners make it very difficult for prisoners to find lawyers. So most of those cases, the overwhelming majority of those cases are pro se. And yet again, you're not finding that pro se Muslims are succeeding at a significantly disadvantaged rate compared to pro se persons of other faiths. So money certainly could be a factor. In terms of another factor, a similar type of factor that can drive things is lawyers do make strategic decisions based on what the doctrine is. I suspect we're going to see a great decline in cases brought by those who are employees of religious organizations asserting employment discrimination. Because the ministerial exception has become so powerful, I think those cases will increasingly simply not be filed at all. So we're likely to see fewer of those cases adjudicated. A similar change happened, but has been since reversed. Employment Division versus Smith, if I recall right, 1984, 1986, somewhere in that neighborhood, really set religious liberty claims back significantly, because the Supreme Court in that case held that the free exercise clause does not protect someone who is subject to a generally applicable law, even if it has a dramatically burdensome effect upon the religious values. But the court said, of course, religious liberty claims could be brought under other theories, such as free speech theories. So for a short while, there was a pretty dramatic uptick in religious liberty claimants relying upon the First Amendment free speech clause rather than the First Amendment free exercise clause. Congress then responded with the Religious Freedom Restoration Act and other statutes, and the Supreme Court has since been much more likely to scrutinize a claim that there really is equal protection and say it's really not, equal application, it's really not applied equally at all. And so the free exercise clause and the religious liberty cases have bounded back up, and the free speech part of it has fallen back down to traditional norms. So certainly it's true that litigation actors do respond strategically, especially when counsel's available to make those strategic choices. Any questions? Anyone else in person? Go ahead.
Sure. I'm going to combine these two because I think
Sure.
ask a very similar question. So it's just a generalized question of defining religion.
Mhm.
And then there's a specific question here within that, which is regarding the ministerial exception. Again, the question of what's the definition of religion? And there's an example here. In PGA Tour Incorporated versus Martin, the Supreme Court decided that it could determine which aspects of golf rules are essential and which are not, even though this required them to overrule the foremost authority in the sport. So if the PGA Tour had presented themselves as a religion, would it have presented as a different outcome?
I think in that particular scenario, no, because we would recognize that it wasn't a sincere assertion that the PGA is a religious organization. But in terms of those kinds of factors, talking about how you define religion, that's obviously a very important part of this. And if you get that wrong, then the data begins to become very problematic. So our approach was to accept what the claimant says about themselves. In most of the cases, not all of them, in most of the cases, the claimants are pretty specific in defining who they are. There are cases in which the assertion is of a more general spirituality, and we categorize those separately, but we did count those. There is a category, this is going to be my teaser for you all to come back again next year. There is a category of claimants that I haven't talked about today. If you want to see what our findings were and what our thoughts were about that, feel free to download the article, but something that I plan to come back to next academic year. What about those who assert religious liberty claims but are unaffiliated with any religion? The so-called nuns, and we were chatting before it began. When you're in a Catholic setting, you've got to be careful to spell that correctly. I'm not talking about N-U-N-S, I'm talking about N-O-N-E-S. The demographic of Americans who choose not to affiliate with any religion. And that demographic has grown dramatically over the past few decades, and it has grown dramatically among judges as well. Now, having read quite a bit about the nuns are a really broad category that includes a lot of different things. There are those who are atheists, there are those who are outright secular humanists, but many fall into other groups. I don't affiliate with any organized religion, but I follow traditional Christian values, for example. We would categorize that person as a traditional Christian, even though they don't affiliate. Others, it's more of a general spirituality, and we categorize it that. For those who really are not affiliated at all, who really qualify as nuns, our study found that they do significantly fare less well in bringing religious liberty claims. Now, some might say, well, that's kind of a no-brainer, right? I mean, it is the free exercise of religion clause. So to assert a claim for free exercise or accommodation when you have no religion behind it is problematic. That certainly seems to be the way that the courts are perceiving it. And if the courts determine you have no religious content to what it is about at all, you're not going to be given the same kinds of protections that the Free Exercise Clause and the Religious Freedom Restoration Act provide. So that it appears to be truly happening. Whether that's the right thing to happen, that's another question. And I think that's part of what hopefully you'll all come back to for some program on that next year. We're talking about how to do that in a way that we bring in both sides of that kind of approach, just how broadly should the religious liberty protections apply to those who are unaffiliated. Those, of course, who are unaffiliated and are objecting to being forced to do something religious, that, of course, the courts recognize widely. But to say, I don't have a religious belief, but I don't want to be subjected to a vaccine mandate, should that person be treated the same as someone who does have a genuine religious exemption? And at this point in time, the doctrine and the court suggest the answer is no. And our study suggests the courts are following.
I have one quick question.
Sure.
I'm curious because we didn't entirely talk about like the biases and that type of thing, but I am curious in terms of like, I noticed the data is from 2006 to 2015. And of course, there's always the concept or idea of public opinion or public commentary. So, you know, post 2001, for example, animus towards Muslim communities or communities that looked like the Muslim community. I'm curious if there's any sort of factoring of that within.
There's no way to code that. It certainly can provide some explanation. I think that is an important explanatory factor in why Orthodox Catholics and Baptists fared less well during that 1986 to 1995 period. You know, the types of cases that were being raised were those that you would think of as fitting the culture wars. You know, something as my colleague Tom Berg and others point out to think about is, well, there certainly are whole swaths of the country in which someone having traditionalist Christian values are not going to find any conflict with government. We're a heterogeneous nation. And even in a state like Minnesota, there may be many counties in which that simply doesn't arise. It might very well arise if you encounter that in Minneapolis, for example, that there are areas in which those on the other side of the culture were very much in control. And so I think that certainly played an explanation. The Supreme Court responded to that. Congress responded to that in part. And even if Congress maybe has changed its mind somewhat, that'd be harder to happen today. The statutes are still there, and it's unlikely they're going to be repealed. If the Supreme Court is out of step with the majority of the country on that, well, nevertheless, it still gets to make the decisions. And it has, and you know, despite partisan concerns, which I'm sure will come up again, and those divides will show themselves even in free exercise somewhat, it has to be said the Supreme Court's most significant religious liberty decisions in recent years have been super majorities. You know, the Hazana Tabor case, you're talking about the liberal members of the court expressing just as much concern about government imposing its values through employment discrimination laws on religious groups, as did the more conservative judges. And as I point out, the recent case involving the right of someone being executed to have religious counsel at the execution, that's an 8-1 decision. So I think, you know, talking about post 2016, one of the things that I think the partisan divide may be attributable in part to COVID cases, because they're those who were more conservative, more Republican, were more likely to be concerned about COVID restrictions being too great and imposed too broadly. Those on the more Democratic or liberal side thinking that's a good thing to have that kind of control. And so when we do our next set of studies, one of the things we'll need to control for is COVID cases versus other types of cases, because it may be that there is a significant partisan divide in the COVID cases and less so in others. Again, I can't predict that until we actually get the data. So 2022, hopefully 2026, stay tuned, 4 years, we'll be back. I think we could probably take, yes, one more question.
Quick question. Do you have an opinion on the government workers, the minority of them that are going to be fired because they haven't had vaccinations?
I haven't gotten deep into that. I can see the arguments in both ways. First of all, a religious exemption, I think, is different than a non-religious exemption. And so I think that makes a difference. And there, boy, that's a hard one, because, you know, that's where I think that what Mark DiGirolamo talks about, you know, tragedy aspect of it. I certainly see the government's concerns that not having a vaccination has a public health hazard that puts others other than the person who's not vaccinated at risk. It's not just about their health, it's about the health of others. And yet, of course, science is not perfect. We've always had a certain percentage that weren't subjected to vaccine requirements on the assumption that most would have it, and so it wouldn't, so the compelling government interest would fade. And I know individuals who find that a very painful choice to make as to whether to become vaccinated. And so that's one of those things that's very difficult. My hope is we get past it. I'm hoping that will come. Maybe that's a good point on which to end, that it's good to be back in person. Let's hope that COVID behaves itself so that we can continue to be in person. And that we will, within a few months, be looking back on not paying any attention to whether there's the latest surge or not. And I know that that's something that both sides of the vaccine issue would come on common ground. We both would like to see that be at an end. So thank you very much for attending. And for those of you who are online, we have a lot of great programs planned for the fall, including bringing back the Hot Topics Cool Thought program. Which we're planning for October and November, on whether qualified immunity should be abolished. And we will have the pro and the con on that presented. So once again, have an opportunity to bring in opposing points of view in a civil discussion. So thank you for being here.